The Senate and House Judiciary Conference Committee will come to order. When we left, we had a couple of discussion items we were working on. One of them is Senate Bill 500. So if we'll call that up again, and the Senate had made an offer to the House of a couple of amendments.
Thank you, Madam Chair. And the House is appreciative of the amendments and for the most part, very happy with everything. There were just, as we read through it and more in depth, there were a few little tweaks that we would like to make. And so we have just been on the go since then and haven't really had a chance to look deeply at what those would, we have some ideas, but we just haven't figured it out completely. So we would like to thank you for the offer, let you know we're 90% there, but we just had a few things we needed to do. So if we could have until tomorrow to finalize that, we would appreciate it.
I'm not sure the legislature will be here tomorrow. So that kind of puts our feet to the fire. So can you proceed?
I guess we'd need to run out in the hallway and talk, or we could finish up a few things and first, or whichever order you'd like to do, Madam Chairman.
Thank you, Madam Chair, and I do understand how busy everybody's been. Have you had a chance to talk to Reviser and have a balloon amendment drawn on the tweaks? I understand. I just want to ask where we're at.
Thank you, Madam Chairs. I did speak to the Reviser, and I also spoke to your Chief of Staff about it. So I'm speaking to people, but we haven't. The main problem I'm having is not so much, I don't think, with what we're trying to accomplish. I think we're trying to accomplish the same thing, but I see some ambiguities in the language which I wanted to try to clear up.
Are we able to verbally discuss those? And the revisers are here listening, and just talk through it. That's often how conference committees progress, and
excuse us for just a minute. We'll get our thoughts together, and then I think we'll be able to come back with something. Okay, thank you, Madam Chair and committee. So I think what we would like to do is just, as you suggested, mention some of the concerns that we have that we would like the language maybe to be clarified just a little bit. And then, Representative Lewis will kind of take charge of that since he's looked most closely at it. And I'll hand it over to you.
A lot of this is in the form of a question, and maybe you can answer it for us. The retroactivity provision that you added on page 3, as I understand it, and correct me if I'm wrong, does that mean that somebody whose privileges have been suspended before the act becomes law can then go into court and ask the court to retroactively apply the new law? Is that what I'm understanding? That
We'll probably have to share that microphone with Senator Wilborn because this one I don't think really reaches.
Thank you, Madam Chairs. The intention, as I understand it, the provisions of this paragraph shall be construed to apply retroactivity. The intent was to be clear on that. Apparently, we weren't. It is to go back 5 years, and anything before that, I mean, that's the period, and they can then be could move forward with the process.
Does the reviser have some clarification?
we're talking about page 3, the retroactivity in the balloon amendment.
Thank you, Madam Chair. I think the intention is just that those violations that can lead to a suspension will not lead to a suspension, and that would be applied retroactively. That's all it says. If the further question is how that would be implemented, I don't know of a way that a court could do that on their own, sua sponte, to use the Latin term. I think you would have to petition. I don't know that there's any other way to do it.
So if I might, so in my scenario, then the person who had been subject to the old law would be able to come in and petition the court to then apply the new law. Is that your understanding?
Representative and Madam Chair, I think a court could entertain that motion. There's an interesting question about how you would file that petition. I guess you would have an existing case, and you would be able to file it in that case, I presume. But yes, I don't know how a court would know to go back and look at whether you were convicted, whether you violated this section based on a violation of one of those underlying offenses, unless you brought that to their attention.
Right. And then the other question, Senator Wilburn, you mentioned a 5-year look back. I'm just asking, can you find that provision in the law? I'm sure it's here.
Or if the reviser can identify that.
Madam Chair, that's the new H1, the 5-year.
What page is that on?
The final page.
That's on the balloon.
Yeah,
the balloon on page 8.
In the version that was sent to the House, it was subsection H, and it's in the balloon. It's also subsection H, but specifically H1.
So okay, so that's another ambiguity that I needed to be clarified. I'm looking at the balloon on the last page, H2 in particular, and the second sentence says the division shall notify the individual that the individual may be eligible for driving privileges as a result of the expiration of 5 years from the conviction for the failure to comply. So are we saying then that after 5 years, your suspension is eliminated? There's the may in there, and I didn't understand under what conditions. Yeah, I didn't understand exactly how that was going to work.
Is that something the revisor can provide?
Madam Chair, I can only give you my best guess at this. I think this is the standard division language. You'll recall that you could be suspended or restricted for a number of reasons. So frequently in the traffic laws in Chapter 8, you see that something like your privileges may be restored unless you're otherwise suspended or restricted. So the division would be notifying you that this expiration has occurred, but they would have to do a further check of your record to see if you actually are eligible to be restored. There might be something else in your record that's preventing them from doing it. I think that's why it's may. If it was shall, they would have to do it even if there was something else in your record. And the policy is you would not want them to do that. So I think that's the reason for the may. They have to notify you, but then there's still another review that has to happen.
And that review, if I might, would be done by the Division of Motor Vehicles. Another question I have is once again in the balloon it says at the top, prior to issuing an order pursuant to this section that either restricts or suspends an individual's driving privileges, the court shall, and then it lists several things it shall consider. And then it starts with what constitutes substantial compliance with the order for the individual to regain full driving privileges and the corresponding timeline for compliance. It seems to me that's redundant because in section that follows this balloon, it defines substantial compliance. So I'm not sure why we're then requiring the court to prejudge what would constitute substantial compliance. I think that would be an assessment made by the court if there's something that looks like it's not compliant. Because as I say, this is all something that the court is being directed to do before it issues the order. Second B, what constitutes a late or missed payment and the penalties for late or missed payments to be imposed by the court, including a process for restarting payments or notifying the division of vehicles as a result of the failure to substantially comply. Once again, I think that's presumably there's going to be an order saying you're supposed to make these payments by a certain date. I'm not sure if this isn't also redundant and kind of confuses things. And then the court's supposed to consider a waiver, reduction of fees, fines, and court costs, and allow for payment plans for fees, fines, and court costs. I'm asking the revisor, isn't that also basically what is in the bill? It's the original bill. The court's supposed to consider waivers under hardship conditions.
Madam Chair and Representative. So the underlying law has a mechanism for a person to petition the court to receive a waiver of fines and costs. And so the original bill, the bill as amended by the Senate committee struck that provision and had the hardship and waiver provisions that are there on page 6 in its place. So when the House removed those provisions, you put back in the current law, which begins on the bottom of page 6 and then goes on to page 7, that the person assessed a fine or court cost may petition the court to have that waived or reduced. They have to show manifest hardship or similar things that are listed there. So yes, I mean, because of the way the House changed that provision, if you wanted to adopt this provision, you might need to consider some policy choice there. Do you want it to be upon request, upon petition, or do you want it to be considered by the court up front? And those two may not quite work as well as they should. And that's just one of the things that happens when you're putting different versions together. We may not have worked that out yet. So.
And then on D, under the balloon, once again, 1 big D. It's supposed to consider alternative requirements in lieu of restriction or suspension of driving privileges, including but not limited to alcohol or drug treatment or community service. I'm assuming then that we're directing the court that those could be alternatives when we're telling the court to consider that. Is that your reading? And then once again, this is more the way of a question than not taking position on this. The provision 2 under the balloon, nothing in this section shall be construed to require the court to make written findings or written payment plan orders. I mean, if we're serious about this, then the court should make written findings and a plan for payment for the sake of giving notice to the defendant as to what's expected of him or her.
Are you ready to make a counter proposal or some suggestions now that you've had your questions answered?
I don't think I've had my questions answered, and no, I'm not prepared because I haven't had time to.
Well, we're listening if you have some drafting suggestions, or what's your pleasure, I suppose, with the Senate's offer?
If I may just ask a question, is it your intention that the court they don't need to do written findings or payment plans, but of course there's going to be a written order? Is that the way I understand that number 2?
I think it's wise that we ask the revisor that question. That's my understanding. Madam Chair, if you would like to repeat that for the revisor.
Yeah. So would you say, in your estimation, that number 2, of course, the court still does have to make written orders, but they just don't have to uh, do the findings by writing them or no written payment plans. But I mean, surely an order has to be written so the defendant knows. I mean, is that how you would take that one?
Madam Chair, I think if I understand the current practice correctly in the courts, they're doing a lot of this more informally. And that's part of the reason they didn't want to be tied to a written finding or a written payment plan order. And you do have to issue an order that suspends or restricts, right? That order is required by the statute. But lots of other orders can just be issued, as a bench order, right? Just orally on the record, right? And so I think that's meant to facilitate that practice of here's your payment plan. I expect you to pay this much per month. And if you don't, come back and see me in 3 months and we'll see how you're doing. That's sort of an order that's just verbal. And I think this is intended to facilitate that practice, if I understand right.
Okay, so I would like to go ahead and just do a counter to begin. So I am on your balloon prior to issuing an order pursuant to the section, blah, blah, the court shall consider, just leave out A, B, and C, because A is taken care of right next to that with a definition of substantial compliance. And then they would already have said what a late or mispayment is in the order. The same with if they have a waiver. So just go straight to the court shall consider alternative requirements in lieu of restriction or suspension of driving privileges. including but not limited to alcohol or drug treatment or community service.
I would just say too that in light of what we just heard from the revisers, I now have better understanding of number 2, which is they don't have to make it in writing because they're putting it on the record. So I think we probably agree to leave that in.
Do you have further proposals to make?
On retroactivity, I think this was the intention of it. That
Okay, so then the other thing would be the retroactivity at the bottom of the balloon, number 3, just add a phrase that makes it clear that that has to be by petition, that that there has to be some sort of formal action for it to be retroactive.
and the point is that the court's not sua sponte, or the Division of Transportation isn't sua sponte obligated to inform people that they can come in and retroactively have their adjudications re-adjudicated.
Do you have other suggestions?
Just what that's what we're saying, that it would say by petition.
No, I'm sorry, on Senate Bill 500.
This is Senate Bill 500.
Yes, I'm meaning, do you have other changes to propose? I'm moving on from the retroactivity proposal.
That would be it.
Okay, let us go confer in the hall for a moment. Okay, thank you for the brief recess. The Senate counters with this offer, doesn't accept that offer, but does counter with uh, it's important on the balloon on page 8 when the court is considering and articulating its plan for repayment and things like that. We want it to do it carefully, and we want the court to have to consider the factors that are in the balloon. So the counter proposal is the Senate can agree to the striking of subsection 1A and B as proposed by the House, but keep in subsection C there under 1C. That's been a really important part of the discussions here because the reason you've been suspended or revoked is because you haven't paid the fees and fines and court costs that have accumulated, and it's really a workforce issue is what this bill is, to allow people to have driving privileges so they can get back to work. It's a position that's supported by the Kansas Chamber of Commerce, the Wichita Chamber of Commerce as well. And as far as regarding the retroactivity, yes, it's agreed that we need to have it be consistent and that notice will be given. So by this law, if this bill becomes law. So it's not going to be the court acting sua sponte, and it's not going to be the defendant having to petition the court. It's going to be automatic if this bill becomes law, that they will receive the notice about you may be eligible, just like you will receive the notice back here on page 8. It's going to be one notice is the point, so that they will have some opportunity there. And did Senator Corson, did you want to add something?
I think you did an excellent job of summarizing that. I mean, again, would just add, I mean, that language that you outlined in 1C, I think was kind of very important to the Senate position, and it's kind of always been core, keeping C and D together. And then with the retroactivity, I'm a little bit over my skis because I admittedly don't practice in this area, but as you stated, it's not clear to me that you would necessarily have to petition the court on the balloon on 3. I guess that's G, C. I mean, I'm wondering if Division of Vehicles could, again, as the chair stated, provide just this similar notice that they're providing on page 8. So I don't know that you would necessarily have to go into court. But again, I feel a little bit out of my depth on that.
Would it be the one notice? I'm asking the reviser. Well, we're not really here on behalf of the division or the department or anything, but so the counter offer is the Senate can accept the striking of 1A and B on page 8. Well, A and B of section 1 is the balloon on page 8.
So I'm still confused as to how this would play out. So the division gets notice to somebody that 5 years has passed and they may be eligible to have their driving privileges reinstated. And then are we contemplating that the defendant then goes to the division or the court to get them?
I think there's
stated.
contemplated a form would be provided that you can apply for your driving restrictions to be reinstated. Or am I not remembering this correctly? And we are eventually going to have to move on because we have other bills to take a look at.
I understand, but we've got to get it right too.
We do.
Respect.
So I'm curious, if I may, it does seem like this number 3, the provisions shall be construed and applied retroactively. We don't really know what that's going to look like for the division, how it doesn't say they will They are eligible, but they may be eligible. So if we think it's wise to just leave it at that, like, okay, they're just going to figure it out, then I think we do that sometimes. But if there's another suggestion on kind of what the step would be for the person to find out if they are indeed eligible, then would we have them go to the court or would we have them go to the division? And I'm curious, like, if since we already said the other part was retroactive, do we need to say it here too? Because
Well, the Senate is going to add to its counteroffer to accept that on page 3 that we'll put in, the provisions that you have to petition to have the provisions apply retroactively on page 3 as suggested by the House. Make that consistent if we need to in page 8. Yes, with and strike sub A and B of paragraph 1 in the balloon on page 8. Well, hold on a second. We're gonna I'm about ready to move on to a different bill and come back to this, so that maybe you can have some questions answered offline by the proponents who are putting this together.
make one last offer.
Sure.
Thank you for adding by petition on page 3. We're
Well,
fine.
that's only part of if you're accepting
Yes. Okay.
striking A
Yeah.
and B or
Yes, we're fine.
B and C.
Yep, we're good keeping in C and keeping in D. And then I would ask that we just leave out this number 3 because it's retroactive already on the first part. And then what is retroactive in number 3 is just this subsection that talks about them notifying the individual.
I think it's important if we're clarifying it's retroactive, we should keep it in there because it helps clarify. That was the intent of putting in stating specifically it's retroactive.
But is it just saying that notifying them is retroactive? Because it's just this subsection that's retroactive.
Well, that's why it's retroactive is stated on page 3 also.
Okay, maybe should we move on?
Well, do we have resolution here or agreement to our counteroffer, to the Senate counteroffer?
Okay, just to reiterate, I think we're good with what we want to do in section 1. We're keeping in C and D. That sounds great. We're fine that we're going to add the by petition on page 3. I think the only hang up we have at the moment is what to do with section 3 at the bottom of the balloon. We could say there is some language that we could possibly say that the provisions of the subsection shall be considered retroactively if they apply. We had some language from another bill.
If the defendant makes application, and then the question is whether it makes that defendant applies to the court or to the division. I just think it needs to be clear what our intention is.
The Senate understanding is that the letter from the division will explain to the driver, to the defendant, I suppose, what the next steps are. So it is going to be clear in the letter that what your steps forward are. So, and it's important position of the Senate to keep in that the statement about it shall be applied retroactively. Because again, what the bill intends to do is that if it's been more than 5 years and you haven't paid some of these, and it's prohibiting you from getting to work because you don't have your driver's license, there's a path forward for you once you get this letter, and you can see what your next steps are if you're going to choose to do that.
Okay, thank you. Give us just 1 second. Okay, that we will accept that offer, that counter offer.
Okay, great. And then, so with that acceptance of the counteroffer, do we have agreement on Senate Bill 500 as we've just amended it for the CCR? It sounds like we do. Okay,
The advisor understands the agreement.
correct. Okay, great work, committee. Yes, we're going to continue our work just a little bit because Senate Judiciary does have a conference committee meeting with House Corrections. But we are all here assembled, so I want to push through a couple of other things that we've been talking about. And one of them is Senate Bill 458. That's civil asset seizure and forfeiture. And when last we met, we were talking about, well, whether there were any studies and things that maybe the House wasn't as familiar yet with. So I wanted to bring those up that were presented in committee, so they're online and available. That some quotes by the United States Supreme Court from 2017. Civil forfeiture proceedings often enable the government to seize the property even when the owner is personally innocent. And also that the forfeiture system has led to egregious and well chronicled abuses. Forfeiture operations frequently target the poor and other groups least able to defend their interests in forfeiture proceedings. Perversely, these same groups are often the most burdened by forfeiture. They are more likely to use cash than alternative forms of payment, like credit cards, which may be less susceptible to forfeiture. And they are more likely to suffer in their daily lives while they litigate for the return of a critical item of property, such as a car or a home. That U.S. Supreme Court case goes on to state that in recent decades, again, this is a 2017 case, in recent decades, civil forfeiture has become, quote, widespread and highly profitable. The government's forfeiture, quote, practice has become a veritable addiction for federal, state, and local officials across the country, close quote. And then there's an article from also 2017 from Harvard Law Review about, quote, reports of police departments creating wish lists of assets they want and choosing raid targets accordingly, close quote. And some of the studies include a 2019 study that talks about police departments who collect higher shares of their revenue from fines, fees, and forfeitures solve crime at significantly lower rates. And that's a June 2019 study. Some of what other states have done: 3 states have abolished the practice of civil forfeiture entirely. 15 states require a conviction in criminal court before a civil forfeiture proceeding can occur. Since 2014, so in the last 10 years, 25 states have increased forfeiture reporting requirements, and 7 states and Washington, D.C. have passed laws to prevent local officials and the federal government from circumventing state law through the equitable sharing, the adoption. And also, we haven't really talked about the court. If you no longer have the asset that's subject to forfeiture, they can order a replacement um, piece of property of equal value of what was seized. And if you are asserting your Fifth Amendment right to not self-incriminate yourself, that assertion can be used against you in the court proceeding. And you can still be compelled also to testify. So there's a lot here that we've taken a look at. Those are just some other assets or other features of the current process. And you had asked for some more information about what that looks like. So the Senate, I guess last we had talked, I don't think the House had any offer, but to move this along and in the spirit of compromise, the Senate would like to take a look at the 3 provisions that we had, the differences in our version versus the House. And one we've talked about kind of extensively was we'd like to reoffer the reporting requirement to the legislature of the activity that's been going on already, that's pretty much already being reported, but just a report to the legislature directly as well would be part of the offer. And then regarding jury trials, the offer would be, we've heard some question about, well, if there's fee shifting involved, as in the House position and in the Senate position as well, the fee shifts, the defendant gets reimbursed their reasonable attorney's fees if they win 51% of their seized property back, but there's no jury trial. The Senate offer would be, if there's a jury trial, then that fee shifting position or that fee shifting procedure doesn't happen if there's a jury trial. But the court may award reasonable attorney's fees if, under the totality of the circumstances, the court deems that that would be appropriate. And then the third piece on the federal adoption, what we're looking to do here overall in Senate Bill 458 is not, like other states have done, to prohibit the practice of civil asset seizure and forfeiture, but to put guardrails. And we've heard other bills in this conference committee that we're not looking to prohibit, but we want to bring some transparency and some guardrails and shed some light on this process. So the jury trial would do that. It's and it would be up to the defendant then to decide, do I want to hire an attorney to help me with a jury trial? Do I want to do the jury trial on my own? Do I not want a jury trial? And then there's been some concern about the expense for the seizing entity, and with the change in the fee shifting arrangement, that would help address that. And then finally, with the adoption, some guardrails we have proposed are the following, and I'll get this to you in just a moment. But the guardrails are that the state or local agency may request federal adoption of a seizure only if it occurs pursuant to a joint task force with federal law. And I'll pass this out in just a moment. Uh, the seizure occurs pursuant to a joint investigation with federal law enforcement or as part of an ongoing investigation. The property seized by the agency is subsequently seized pursuant to a federal seizure warrant. The property seized by the taking agency directly relates to a serious public concern, or the gross estimated value of the property seized by the agency is $75,000 or more. So, with that, that is kind of a brief overview, but these are not new subjects that we haven't already been discussing. So, if we have the balloon for the revisor to pass out, that would be helpful, and I can direct you to the pages where those changes are directly. The first thing you'll see is just some changes to the title of the bill, but the first change in substance is on page 7, and that's the federal adoption piece on page 7. And the jury trial piece we had to put back in on page 13. Some of that there on page 13. And on 15, claimant may demand a jury trial. And then the reporting, I think, if I'm correct, starts on page 16. Oh, on page 16, I'm sorry. We're putting back in, well, if you want to explain section 8 on page 16.
Madam Chair, this is KSA 60-4114. That's the in personam forfeiture proceeding. So the one before it is the in rem. It has the jury trial procedure. And then this one would need to be put back in the bill just to put in the jury trial procedure on page 17.
Thank you. And then regarding the fee shifting, if you have a jury trial, that's the bottom of page 19 as well. And the revisor will correct me if I'm wrong. And federal adoption is also on page 20. And then if you'll explain on page 24, the strike through.
Madam Chair, the strike through in section 10 was in the bill. That's dead law that expired in 2019. The strike through of section 11 was what the House did, and you would restore that section on page 27. That's the reporting section.
Page 27, the reporting, it cleans up some of the date. And then at the bottom of the very last page of the packet is the reporting to the legislature.
Just a quick question. Could you say the page number again that talks about the fees if there is a jury trial? Okay.
Sure, page 19. Thank you, Mr. Revisor.
Could I just, if we may,
Yes,
just
please.
ask another question? I did have a question on the page 7, the balloon about the federal adoption. Number D, the property seized by the agency directly relates to a serious public safety concern. Is there a definition of serious public safety concern either in this bill or in our statutes?
The purpose of that is to leave it to the discretion of the agency who's involved in the seizing, and that is from federal law as well. They have guardrails, some guardrails in federal law that has that same sort of language.
If I might, Madam
If
Chair.
I'm correct on that, but yes.
Who do we contemplate is going to make that determination as to whether there's a serious public safety? Is that going to be made by the court, by the state agency, by the federal agency?
Well, the state or local law enforcement agency may request the federal adoption if if one of these 5 circumstances exists. And so that would be the state or local law enforcement agency making that determination, because the state or local law enforcement agency is the one going to make the request, if I have that correct. So it would be the state or local law enforcement agency.
I think we'll go out in the hall for a moment. Okay. Thank you, committee, everyone, for getting on with this and bringing it up. We're going to each speak to different parts and then I'll probably wrap everything up. So, as far as the reporting goes, we do think that that is a good idea as we've talked about it and thought about it. And reporting to the legislature does make sense. So, we'll take the Senate position about the reporting. And then, of course, there's two other areas of contention or difference, and my ranking and vice are going to each speak to those. And so, go ahead, Representative.
Thank you very much, Madam Chairs. I'm going to speak to the jury trial, and I think that I have a strong opposition to that. And it's the strong opposition is not to the jury trial itself, but how this is structured, because it puts both the attorney and the client in a very awkward position. What you've got here is a situation where um, we negotiated on fee shifting, and that was the reason why this whole thing came about as for asset forfeiture. And it not only was a compromise in judicial council, but it was also got the ball rolling. And the reason why is because now we have attorneys that can take claims that normally would be so far out of bounds for any attorney. Um, to do. We were talking about it costs $30,000 or so to litigate a particular case. You're not taking a $500 claim. You're just not. It wouldn't make any financial sense. That's why the fee shifting as a possibility is in there. When you introduce the situation of, okay, there's a jury trial, but the jury trial eliminates the ability for the fee shifting, you end up with a very awkward position for the attorney who now needs to say, this does not make financial sense to me anymore. And I cannot support having a client for a $500 claim, knowing I'm never going to get reimbursed for it. This happens halfway through the process, where, say, the client comes to them and says, I would like to have a jury trial. How does the attorney come back and say, no, you can't have a jury trial, you can't afford me, or no, I'm not going to be able to represent you anymore? Where does that leave the client at that point? And the client now needs to also make the determination, and do I go forward without an attorney at this point because I can't afford legal fees? It is a financial conundrum and an ethical conundrum for the attorney.
I'm going to go ahead and respond just so we can recall what the comments were. Thank you for the offer from the House on the reporting. I think we're all interested in bringing transparency and accountability. That's what this bill overall is all about. So thank you for that. As far as the jury trial, we have written statements from some law enforcement entities that the cost of an attorney is $5,000 and most takings are under $3,000. So you are automatically at a loss, even if you win your even if you win your trial. And it is shocking to me that the position is to deny Kansans and others who visit Kansas a jury trial, which is a foundational element of our American jurisprudence. That when we have government seizing your property, and I think 2/3 of the time it's literally an interaction with government on the side of the road seizing your asset, that we are then going to deny that person, if they so choose, the opportunity for a jury trial. It's a foundational element of our American jurisprudence, and it is not a conflict of interest for a attorney to have a conversation with a client about the expense of litigation. It happens all the time. That's what attorneys and clients do. So when we, as the legislature, are looking at foundational elements of, again, American jurisprudence, one of them is that You be afforded the fair opportunity to be heard when government takes action. And if we are denying uh, defendants who have been charged with no crime the opportunity to put it before a jury of their peers, a jury of peers in the community. This is what happened to me. This was the seizing. Do you think this was fair? And if it was a proper procedure, what would government be afraid of to show that in the light of day that this was a seizing that was appropriate? So the Senate has a strong position that there be a jury trial in all circumstances. That passed out of the Senate very favorably. And the offer of the Senate is to reach a middle ground because the House didn't want any, under any circumstance, is the House position. No jury trial in any circumstance, even if you have a plaintiff with, or excuse me, a defendant with lots of resources, no jury trial. So, to reach a compromise, the Senate has made this offer, and so would wish that it would be duly considered. But if it's being, we have a statement. I don't know if that's a rejection of the offer, but
We're going to continue and talk about the offer, and then I'll sort of sum it up at the end.
So thank you for that that debate on the jury trial. I'm going to address the adoption, but before I do that, I would like to respond. The jury, you're right. It's a fundamental principle in our Constitution to have a jury trial, but there's been no determination by any court that I'm aware of that in these circumstances, the common law provided for a jury trial. I have read Justice Thomas's dissent in the denial of a certiorari petition, where he suggests there might be one, but that's certainly not currently, at least, the firm holding of any court that I'm aware of in the country, certainly not the Supreme Court. I share my ranking representative's concern about the dilemma that the offer on fees creates for the lawyer, because the circumstance could arise, and it was alluded to that you, the lawyer, enters into an agreement with the client that he's, and the contemplation is, for instance, that he's going to demand a jury trial or a bench trial. And then as things develop, he changes his mind and says, oh, by the way, I think I want a jury trial, or I don't want a jury trial. And that completely changes the financial circumstances for the lawyer. That's not fair for the lawyer. On the other hand, because you can't go into the case saying to the client, in no circumstances can you agree to a jury trial or not. So it creates a very awkward, almost impossible position for both the client and the attorney. Going to adoptions, I've already explained. Well, we've already talked about how this idea was discussed both at the Judicial Council and in the interim. There could be no consensus on that point, and therefore it was essentially not part of what was recommended strongly by the Judicial Interim Committee, on which 4 of the attorneys sitting at this table were party to. And I would suggest to you that the 4 of us perhaps had, and I know in some instances did have, different views on adoption, some thinking we should have it, some thinking we didn't, but it didn't obtain the majority of the votes in the interim, and that's the reason it wasn't put into the House bill. I've also already spoken, and I firmly believe that if you start to put restrictions on the ability of our state and local law enforcement and prosecutors to work adoptions as they see fit with the federal government, you're going to significantly reduce that. And you're not only the adoption, but you're also going to reduce the cooperation on the entire investigation and prosecution. And I just don't think that that's a wise thing to do. So for that reason, I think I'm speaking for the three on this side of the table that we're rejecting the offer on adoption.
So I'll sum up, and I will first begin by saying nobody got what they wanted in this bill. And the House position is the middle ground. And I know that's not the way you all some of you on the other side of the table feel, because there's House and Senate, and maybe it seems like a compromise would be that middle ground. And I'm just submitting that of the stakeholders that came together and voted and worked things through, they came up with the middle ground, and that was the House position. And the House voted unanimously to get this bill out of committee. I've already had some people tell me today, if we were to change it, they're going to fall off. I don't know how many are going to fall off, but I think it's important as House members that we stay with our position. The reporting, that's fine. We all know that's the least consequential of these three things. Yes, a jury trial is a foundational right of jurisprudence. We all understand that. We all understand that, sometimes the federal adoption, I mean, I don't know personally, I wasn't on the committees. I don't know how that all plays into it. But I will just say I'm trusting that law enforcement is, they don't want to involve the feds unless it is necessary, unless they need help with the investigation, with the task force, with an ongoing crime that they're already investigating. I'm trusting them. And I will say, with the fee shifting, yes, there are sometimes $2,000 seizures, and it costs $5,000 to have an attorney. That's why we changed the fee shifting. So the person that has had $2,000 seized, they can go to court and they can get their money back, and they don't have to pay the $5,000 fee. That's what the fee shifting was about. It is to protect those people that have the small amounts. And so I hear your hearts. We agree, have always agreed since the first time I heard about civil asset forfeiture personally. I don't know about the other two on the side, but yes, and sometimes things are incremental. And some people have said we don't have to come back next year and change it. If we need to come back next year and change it, and we can make this stronger, I am all in favor of that. I think we can do that. So, it is with some sort of understanding that I like things in the Senate bill, but we're going to stick with the House bill except for the reporting, because it was the middle ground and because the House had the strong position and the unanimous vote. With that, I'll let you comment.
Well, there are two chambers of the legislature, clearly, and one of them has a very different position. So the House position is not the middle position, because what could have happened was civil asset seizure and forfeiture been banned entirely. So that's not what the Senate is proposing, but we do have a strong position of jury trials when you want one, a jury trial, period, and a prohibition, period, on federal adoption. So again, the Senate was offering to compromise and come your way when the House is saying absolutely never, ever a jury trial. And the House is saying always, always federal adoption with no guardrails. So, really, in the interest of compromise, the compromise that matters is what we do here today at the conference committee. There's been discussions. The Kansas Judicial Council didn't adopt any recommendations. And again, those aren't binding. We appreciate the discussion and the hard work of those committees. Lawyers have ethical rules of behavior about whether they can get off of a case after they're already in the middle of a case or not, if there's a dispute over fees or something. So that's already taken care of by our Kansas Supreme Court and our ethical rules of conduct. So that wouldn't be a consideration if this were to occur. And again, who are we protecting here? We're protecting government seizing property without the opportunity for a jury trial and with government sending it off to feds for adoption? Or are we protecting liberty and private property? So I think we all know it's the second. We're working on protecting liberty and private property. If you ask the average Kansan, did you know that government can stop you on the side of the highway and seize right then and there the cash you have with you? And they don't have to charge you with a crime. They don't have to convict you of a crime, and they can keep your cash. People are shocked that we allow that to happen in Kansas. And that's what the bill does, is it doesn't prohibit that procedure because it is um, anecdotal evidence that um, it's used in ways that um, may be helpful, but there's no study or facts that show civil asset seizure and forfeiture stops crime. There's just not. So the evidence is with some reform and the reform of a jury trial and some guardrails on federal adoption. So the Senate has made a middle ground, and what I'm hearing is the House doesn't want to move at all.
Before this bill, we don't have guardrails on civil asset forfeiture. After this bill, we've specified certain drug offenses don't give rise to forfeiture. We are requiring courts to make a finding that the forfeiture is not excessive. We're restricting actions prior to commencement of any forfeiture proceedings. We're requiring probable cause, affidavit filing, and a reviewing before the proceedings can be commenced. We're increasing the burden of proof required to forfeit the property up to clear and convincing evidence. And then we're authorizing the courts to order payment of the attorney's fees and costs for certain claimants. That is where we've come from no bill to this bill. There are all kinds of guardrails that we are putting in place. Might we want to put some more at another time? We might want to. But at this point, this is where we can get. This is where we've come to the, I think this is the middle ground from nothing to this. So, and I know we have a difference of opinion about what is a middle ground, and I understand that, but I just want to make it clear publicly that we have come far with those things that I mentioned.
We do have to get back on the floor for debate. So I think both chambers at 8:30. So um, we've got to, then we will be adjourned.